See you then. Edward Dante Morales. Shoof OP 1384098. 21F235822.
All right. I need to blame MGT, Lab Matt, and of course Brecken.
Attorney Mike Baldwin on both cases, for Mr. Morales, who is in custody on.
Mr. Morales, your name? You have to unmute there, sir.
Get the deputy.
I got it. Okay.
Your name?
The host. Am I unmuted now?
I need your full name.
Edward Dante Morales, Your Honor.
All right, you're going to plead guilty, this says, to the charge of resisting obstructing an officer on file 5822 on the basis that you gave a false name. True?
Yes, Your Honor.
That is a
Yes, sir.
misdemeanor punishable by up to 500 fines, 90 days jail, costs, or all those. Do you understand that?
Yes, Your Honor.
Again, you're presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent. You have the right to a trial by court or jury. You have the right at a trial to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you'll be giving up all those rights, and we're not going to have a trial of any kind. You understand that?
Yes, Your Honor.
All right. To the charge, resist and obstruct an officer, how do you plead?
I plead guilty, Your Honor.
I can't hear you, sir.
I gave my false name because at the time, Your Honor, I plead guilty, Your Honor.
Listen to me. Do you plead guilty or not guilty?
I pled not guilty, Your Honor. I mean, no, I'm sorry. I pled guilty, Your Honor. I can't, it's kind of hard to do.
I'm going to ask you again. To the charge of resist and obstruct an officer, how do you plead?
Guilty, Your Honor.
Were you in Flat Rock at 26813 Telegraph on May 21 of 21?
Yes, Your Honor.
Did you give the police a name other than your own name of Edward Dante Morales?
Yes, Your Honor.
And did you give them a different date of birth?
Yes, Your Honor.
Are you on probation or parole?
Right now, I'm on parole, Your Honor, but I'm almost off.
Were you on parole on May 21 of 21?
Yes, I was, Your Honor.
You understand by pleading guilty to this charge, this would be deemed a violation of that probation or parole? It could be revoked. Listen to me, please.
Yes,
It
Your
could
Honor.
be revoked and you could be incarcerated as a result of this plea and conviction. Do you understand that?
Yes, Your Honor.
Still wish to plead guilty?
Yes, Your Honor.
Anybody force you to plead guilty?
No, Your Honor.
Plea is accepted. Now, we have a sentencing.
No report.
I know. What is he in custody at?
Just, I'm looking at the register of actions. It looks like he got picked up. I think he was arraigned back in May of 21 on the initial concealed stolen property. And I think, I don't know how he got picked up, but I'm looking at the register of actions on the.
I know he's got these two. He's got 10,000, 10% on each one. I just want to know if he's got other holds.
I didn't inquire as to his sold.
Can you tell me, sir, are you in custody just on these two?
No, Your Honor, I got a charge that happened in August of 2022 that they just blew it up just now. So
Listen to what I'm asking you.
He's trying to develop credit, and that's where we've had some confusion.
Develop credit.
Time credit in being in.
I didn't ask you that.
No, that's not what I'm saying, Your Honor. I said I'm right now in custody for a charge that happened in August of 2022. Right now, it hasn't even been adjudicated. There's been no preliminary examination yet.
Oh,
So,
all right.
and I was given a PR bond for this charge right here. And
Which
and I was-
charge? Which
the charge
charge?
I'm in here for, right, but I'm not the charge with you, but for the charge for which on this one here, which is a felony, I was given a PR bond.
All right, so you're just awaiting sentencing.
He hasn't
For
been
your case, I am,
adjudicated on the
Your
felony.
I got it.
And I think I saw a PR in that one of those register of actions, but maybe that was historical. And then it compounded because he wasn't showing. He was arraigned on September 30th of.
Boy, you are really going out of your way to be unhappy here. You know that? Was there a police report in this file?
There was.
I'm talking about in the one for the concealing stolen property. He didn't,
I didn't see a report in the file for that. That's a 2020.
I know.
I didn't see a report. And you're just for edification, it was a sentencing today, so I didn't delve in too deep as to the facts of the case.
Well, I get it. I'd like to be able to sentence him, but I don't.
You don't have a screening and assessment.
I don't have a pre-sentence report. He didn't show up for that. The case been going on for 4 years. Yes, sir.
Your Honor, if I may, I know that when the case occurred, I was incarcerated. Yeah, I got arrested, got incarcerated. I did time at the Wayne County Jail. I remember being released from there. I did like 4 months or more in there. My parole, that's why there's no parole hold on me for that charge right now. Because that I've done time for the parole and for I had a piece of paper when I left the county jail. They gave me a piece of paper.
Slow down.
Okay.
You got a 4,010% bond that I set. I released you on December. I set a bond of 5,010% in December of 20. You were in custody for 5 days. You came back in front of me. I gave you a PR bond. On April 28 of 21, I set a 4,010% bond when you had a warrant out and came in front of me. 7 days later, I gave you a PR bond. And then you just didn't bother showing up.
I think Your Honor, it's not that. Please, I know it's so hard to believe, but please understand, it's not disrespect to this court. That's not what this is about. I know I was locked up for a long time because the girl that was with me when I got arrested.
Not on this case.
No, on this case right here, I got the time because she picked me up and I got out of jail with the piece of paper with this case from Wayne County Jail.
You were in custody for 5 or 6 days from December 11th to the 16th of 20. You were in custody on April 28th when I set a bond 4,010% until May the 5th. You've been in custody since Judge Kirsten set the bond of 10,010% the other day,
September 30th.
September 30. So I'm not saying you don't have some credit for time served.
And that's what I explained that he does.
I
He says that he had
understand.
hold on, Morales, hold on.
So,
He says he had a judgment of sentence adjudicating the case on concealed. I checked the register.
There is none.
No, it's the register, it's blank.
You have gotten yourself in all kinds of trouble because you don't show up.
Your Honor, I'm not disputing that.
You what?
I said I'm not disputing what you just said. I'm not disputing Your Honor.
You should have never, ever had to serve this kind of time on this case. Although I don't know much about you because you didn't bother showing up for your pre-sentence report. And if I let you go, you know what's going to happen?
I'm going to
You're
work. Your Honor.
not showing up again.
Your Honor, that's not. I know you want to believe that, but Your Honor, I've been working at Home Depot. I've been working at Smokers Depot. Smokers Depot on Liberty, Michigan. I can give you the phone number to my boss, and I've been working at Hammy's Pizzeria, 2 places for the past 3 years. I haven't missed 1 day in 3 years, and I haven't had one police contact, not a civil infraction, nothing to do with law enforcement in 3 years, Your Honor. To me, that's fairly good for a guy like me that has a record like I do. I don't have not one police contact, Your Honor, in 3 years.
I'm just pulling out your record here. Let me take a good look at your record.
In over 3 years, I haven't had nothing, Your Honor.
Right. But you've been a criminal for 35 years.
Thank you, Your Honor. That's why I'm saying that's pretty good for a guy like me that's had a record like I did, and I've done good for the past 2 years. All I do, I don't drink, I don't use drugs. All I do is I work. Every day I get up, I go.
I'd have to feel like I should be elected emperor of the world before I could be that arrogant, not show up for a sentencing. Like really, like top two. Only me and one other person get to run for emperor of the world.
All right. Okay. Settle down.
Well, I just miss it. I just like it's a good thing, Your Honor. People like me you don't experience that in your life.
I'm having a hard time understanding you. Just slow down and keep your voice up. Will you please do that for me?
Yes, Your Honor.
And you got quite a history here.
I understand. I know, Your Honor.
And nobody's going to think that you were a choir boy. You know what I'm saying?
Absolutely.
All right. So just let's get past this. If I knew that they recovered the property, that'd be a different thing.
They did, Your Honor. They got the property. It was in the car when I got arrested, Your Honor. It was just a lawnmower. That's on God's word. That's all it was. It was a lawnmower and they got the property. I had originalized it, Your Honor. They recovered it. They gave it back to the
Settle
people.
down. Settle down.
Thank you, Your Honor.
Yeah.
Let me take a look at this. So you've spent some time in jail here because you did not bother showing up is the problem. But stop. I'm telling you to stop. Just don't interrupt me again. You got a warrant out of Dearborn, by the way, which you've had since 2021. See right on your fines and costs. I can't find that stuff now. No objection, fines, costs. Is that what he said? No objection, finding costs, sentence to run concurrent.
With the resisting injury, correct. So whatever jail credit he has, it sounds like he might have 3 small chunks.
Thank you. I got it. I need to talk to you before you leave about something completely unrelated to this, okay?
Yes, sir.
Well, he's right. He hasn't been in a lot of trouble lately. All right, Mr. Baldwin, let's do an immediate sentencing. I can kind of read between the lines here. They caught him with the lawnmower. He says they recovered it. They didn't leave it in the trunk if they knew it was stolen property, so I can believe that. What do you want to tell me before I sentence?
I'm asking that the court sentence my client to both cases to a time served with jail credit to run concurrent. My client has already given a brief background history, recent history of what he is doing with his life. Apparently, he is, within the last 2 years, has been a lot of unproductive.
I know, but the problem is he's almost, what are you, 60? Looks like you're going to be 61 here shortly, right?
Yes, Your Honor.
Aren't you getting tired of doing this?
No, that's why I haven't done nothing wrong in 3 years.
All right, good. Anything else you want to tell me?
Well, whatever you do, I thank you for your time, and I'm sorry that I cost this court time, Your Honor. I really am.
Sorry, did he what?
I apologize for the time I cost this court.
Don't
And
worry
to
about
ta-
my time. That's what I
And to
do.
take something from somebody, Your Honor, I appreciate things a lot more when I buy it and
All
earn it.
right, good enough, good enough. 100 fines, 200 costs, 75 victims' rights, $50 justice assessment. 4 1/4, 17 days on both cases, credit 17. We'll close those cases out, Lisa, send something over and have them released in terms of these.
I appreciate things a lot more when I buy them. Well, yeah, okay, but that doesn't that doesn't mean that's what you're going to do. You're just saying, when I buy them as opposed to steal them, I feel a little bit better about it. Well, okay.
Cases, if you would, please. Thank you very much. Have a good day, sir. Good luck.
Thank you, Judge.
You're welcome.
Thank you,
So-
Attorney Baldwin.
All right, the court will call the case of the state of Michigan versus Timothy Becker, case number 25-00149.
Tiffany Woods for the people.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Becker. It's a pleasure to meet you for the first time as well, Your Honor. Mr. Becker, if you could please state your name for the court.
Timothy Becker.
Thank you. Good morning, Mr. Becker.
Good morning.
All right, we're here for sentencing today. Have you had a chance to review the pre-sentence investigation report with your client?
Yes, Your Honor. I have no corrections to make to the body of the report. Just a couple of things to say by way of allocution and the recommendation at the appropriate time.
Thank you. Ms. Woods?
Judge, I've also had an opportunity to review the PSIR recommendation and I'm fine with the recommendation. However, I just want to make sure that there is some mention of mental health. So I'd ask for a mental health assessment and restitution reserved for the tire for the malicious destruction of property. There was a some restitution that the victim is also asking for as well. So I'd ask for it to be reserved for 60 days.
Thank you. I do note that she's asking for restitution with respect to 2 tires because apparently they told her that they would only replace 2 at a time for balancing issues, and they refused to do 1 tire. So I think that we should just make note of that right now, and then I'll allow Mr. Bernstein to say whatever he needs to say.
Yes, Your Honor. A couple of things to tell the court. We don't have any issues with the restitution request. If the probation department wants to just send that over when it comes in, and I'll share it with Mr. Becker, but I don't anticipate that'll be an issue. Mr. Becker does want to tell the court that he is sorry for his actions. He has no way to describe what happened other than that he handled himself very poorly. He wants to know that he is 40 years old and he's never been in trouble before, never been charged with a crime before. The PSI notes, and Mr. Becker recognizes that he has several diagnoses of psychiatric disabilities, and those have been there since high school. He is well aware of them. He has chosen to live a lifestyle that involves being medication free for that and for not being under the treatment of a doctor. And that has worked out for him his whole life. He lives a very quiet life with, Judge, are you still there? The screen went blank.
You may proceed. I'm listening.
Oh, okay. You went off the screen. So, yeah, I mean, he's lived a quiet life. He's never really been in such a situation before as this before. And I don't think he understood or knew how to really best handle it. He was at a gas station. All of a sudden, a stranger came up to him and just started yelling. I mean, it was just one of these kind of road rage, I was cut off in traffic, so I'm going to yell at you type situations. And he just didn't know really the best way to deal with it. And the way he dealt with it was not obviously the correct way to deal with it. I mean, he should have just walked away, but he didn't really know. And that was just something really shocking to him. And I've talked to him a couple of times, and he didn't really know how to act when that stressor just hit him right then and there. But it looks like in the PSI, he notes that he's sorry. He knows he handled it poorly, and he wishes that he could take it back. I understand there is a request for a mental health assessment and to follow all recommendations from that. That is kind of a point that I want to address. I don't know what those recommendations might be. I don't know that this is a point in time where he needs to change who he is necessarily in terms of how he treats his own condition. He's been able to manage his own, I hate to call it conditions, but his own disabilities, and he's been doing it effectively for 40 years. And I don't know that this situation was necessarily the result of those conditions outside of maybe not having the tools to really deal with it, just given who he is and maybe never being in that situation before. But I don't necessarily want this to be a point in time where he's fixing things that don't need to be fixed. And he's made a decision in his life not to work with doctors about his disabilities. He's made a decision not to take medications. And he would like to continue on that path, Your Honor. And so his concern is that the mental health assessment might change what he's doing and change who he is. And so we are asking the court to reconsider that requirement of probation, Your Honor.
Judge, I'd like to just step in here for a second. He's not managing his condition well, which is why he is where he is today. He stole someone's parking spot at a gas pump. Then when he was confronted about that, he pulled a knife out, threatened to slash her throat with the knife, then went outside, slashed her tire, and spit on her face. That is not something that a reasonable person would do. I believe that he does have a mental health condition, and I believe that a mental health assessment would be appropriate and is needed. A lot of people that are in his situation refuse to take medications because they're in that situation where they're mentally ill. That's maybe what's going on here. I don't know, but we're not going to know anything unless we get that mental health assessment. And I believe that he should have that done. And I would ask the court to order that. Thank you.
And Judge, I respectfully, I want to defend Mr. Becker a little bit because I don't quite read the report that way. I mean, we say steal a police report or steal a parking spot. He pulled into a gas pump and someone came and started yelling at him. He left and went into the gas station and she followed him and kept yelling at him. And then he leaves the gas station and she leaves and follows him and keeps the argument going. I mean, the starting of the fight, the continuation of the fight. I mean, yes, he does escalate it afterwards, but like she keeps following him and yelling at him. I mean, I'm tired of the road rage of stuff that's going on and people just attacking strangers over these things. I'm not justifying in any way. And Mr. Becker doesn't justify what he did. He knows that he handled it wrong. He did, but I just don't agree with the characterization of there. I mean, he's here to take responsibility for what he did, and he pled guilty and he's done that. And I applaud him for doing so. And I applaud him for apologizing for his actions, but I don't know that it just requires a redo of everything in his life and in such an intervention for that purpose.
Right, let's talk about the facts then, since that's what we want to get into an argument about today at the time of sentencing. I think the facts become really important because they diverge. She says that the argument happened outside and that first of all, I'm not sure why he would feel the need to pull a knife on a female. So let's talk about that. And then secondly, she says that he spat on her and the argument was between the two of them. And you're characterizing it as her being the person who was involved in a road rage when she says that he cut her off at the pump. So it could be that his behavior, which is out of control in the first place, caused her to be upset. So why don't we try to figure out more about what happened so we can see what the request really should be, because she would really like for him to do some jail time.
Judge, I'm not trying to.
No, we're there now. There's no trying to. We're there now. So
Okay.
let's figure out more info on what happened that day. So Ms. Woods, it sounds like we need to have some further. Is there a video of any of this? What is the bottom line of this?
Judge, I'd have to look at the police report to see if there's a video.
Because first of all, I don't agree that two people in an argument should result in anybody pulling a knife and pulling a knife on a female and then spitting on her. That's all problematic to me. And if you think that he's managing well by doing that, I think we disagree.
Well, what I'm saying, Your Honor, and I don't disagree with anything the court just said. I'm just saying I don't think it's necessarily a mental health issue. I don't know that. I don't want to say that.
So it's just
the way.
character? That's what his character is like?
No, I'm not saying that's his character. I just don't want to start
It's
putting him on
either-
medication when that's not necessarily called for.
That's why a mental health assessor makes that determination.
Okay, understood.
Apparently the clerk in the gas station says he did not have access to the cameras.
Okay.
But
Hello.
who's talking? Please mute your device.
You gotta do it like this, okay?
Please mute your device. Yeah, it looks like there's no access to the cameras.
I believe that's the case, Judge.
Mr. Becker, what would you like to say, sir?
Like what happened?
If you want to address what happened, you can, or you can just address what you would like to say today about this particular incident and what you want me to know before I sentence you.
I'm just like to say I'm sorry for my part. You know, I try to keep myself, away from society, only out, whenever I can. It's not, like, I didn't expect to be, bullied at a gas pump. I could have just walked away, but, her keep, calling me, all sorts of, names. No, then threatening me when she walked into the store. That's the only reason why I showed her the knife, to let her know that if she keeps bullying me, that's what was going to happen. And then I walked out back to my car, and she just kept going. You know, I'm just, could have just walked away, but you know, stress, trying to quit smoking, which one more week would be officially a year.
Well, congratulations on that piece, Mr. Becker.
And, wrong place, wrong time.
Well, thank you, Mr. Becker. I mean, I think that for me, a part of what we need to figure out is what you need to not make choices like that in the future, whether it's mental health or whether it's some type of therapy that helps you to decide better courses of action when you do have to be in spaces with other humans. And sometimes the other humans aren't going to behave properly, right? So you got to know what to do when they're not behaving properly. Okay?
Yeah.
All right. Thank you. Give me a moment. I want to talk to your attorney and prosecutor, okay?
Alrighty.
All right. Thank you. You can mute yourself, Mr. Becker. Can I see counsel in a breakout room? And probation, yes. All right, we're back on the record in the case of the state of Michigan versus Timothy Becker. I've had a chance to speak with counsel and probation regarding this matter, and I'm ready to proceed with sentencing. So, Mr. Becker, at this time, is Mr. Becker here?
Yes.
Oh, there you are, sir. Thank you. Mr. Becker, I'm going to proceed with sentencing at this time, okay?
Alrighty.
All right. So, Mr. Becker, it's the sentence of this court that you serve 93 days in the Washtenaw County Jail, credit for 0 days served, and all of that time will be suspended. So you don't have to do any jail time at this time, okay? We just need you to follow the court's orders so that we can try to get you the help that you need, okay?
Okay.
All right. You're going to be on probation for 18 months. You'll be eligible for discharge from that probation after you complete 9 months. So if you've done everything you need to do in 9 months, you can be discharged from probation. Fines and court costs in this particular case for a total of $275. Restitution to be determined within 60 days. You're to meet with probation when and where directed, including any and all home visits. You must complete a mental health assessment / neurological assessment to help with socialization, okay?
Alrighty.
And you're gonna you need to have that done within 21 days of this sentence, okay? And you need to sign a release of information so that probation can talk to the counselor or whomever's going to do that assessment so that we can make sure we're all on the same page, okay?
Yes, ma'am.
No contact with Stephanie Sekula. No assaultive or threatening behavior towards her or anyone else. You're to submit to and be responsible for any random drug and alcohol tests, but none are being ordered at this time. No use or possession of alcohol, marijuana, illegal drugs, or drug paraphernalia, or firearm components, or dangerous weapons. And I'm going to see you back in 60 days to see how everything is going with that assessment and what things look like, okay?
Yes, ma'am.
And so I'll see you back here on December 4th, okay?
Yes, ma'am.
Any questions?
No, ma'am.
All right. Did you write down the phone number earlier to call the probation department?
Yeah, I should have it still.
Good. I'm sorry. All right. All right. Mr. Bernstein, can you make sure that he has that phone number if he wasn't on earlier? Okay. Do you have it? You're muted.
Yeah.
I do. Yes, Your Honor. I'll make sure he has it.
All right. Thank you so much. Please call them tomorrow after 9 o'clock. Okay.
Yes, ma'am.
All right. Thank you, Mr. Becker.
You're welcome.
Good luck to you, sir.
Thank you, and you too.
Thank you. I appreciate it.
All right, so let's recall the.
I mean, I still don't know what the norms are because I don't do that all day. But I see it surprised the chat and surprised me too. I thought there'd be jail there for sure.
Matter of the City of Wyandotte versus Robert Allen, 241508A.
Good morning again, Your Honor. Robert Goldman, PA 1222, here on behalf of the Wyandotte and Robert Allen, present in the courtroom this morning. Mr. Allen, would you please state your full name for the record? Robert James Allen.
Okay, and so counsel, you did approach the bench earlier to confirm one of the stated convictions that was showing for your client on the second amended pre-sentence report and recommendation. And then I did step off and spoke to Ms. Shaw, and that she then did confirm again, as somehow there was a misreading somewhere, that it was in fact dismissed.
Yes.
So now you did receive a copy of the third amended report, correct?
Correct, Your Honor.
Okay. Counsel, before we go into allocution or otherwise, Mr. Allen, let me state this, okay? That I understand that sometimes your emotions get the better of you, but my staff is not at all going to be somebody's verbal punching bag. It's my understanding that you were yelling and screaming so loudly at Ms. Shaw that she ended up hanging up on you, which she has this court's full support on. My staff is not to be verbally abused or assaulted. Is that clear?
Yes, thank you.
Thank you. Counsel, you may proceed. Did you have an opportunity to review the report and recommendation with your client?
Yes, Your Honor. And thanks to the court, your staff, and the probation department for the accommodation in verifying that one piece of information that we would discuss at the bench bar. Fortunately, in light of that accommodation, there are no further additions, deletions, or corrections to be made. We are prepared to proceed with sentencing, having received and reviewed in full the third amended PSI report.
Okay, and counsel, as to the recommendation.
Thank you, Your Honor. With respect to the report, rationale, recommendation, and given my time here working with Mr. Allen, as the court is aware, this matter, we've been before you several times over the last handful of months. And, you know, I think that actually provided a great benefit to me in allowing me to work even closer with Mr. Allen to understand him even deeper for purposes of today's sentencing. Your Honor, with respect to Mr. Allen, one of the things that I'm certainly very encouraged by is the relationships that he does maintain with his family, namely that being with his siblings, with his children, with his stepfather. Mr. Allen, while going through the day-to-day trials and tribulations given his physical condition.
Hold on one second. Counsel, just so you're aware, we can hear what you're saying in the microphone, and that's pulling from here. Okay, thank you.
Your Honor, as I was saying, and it's noted within this, the probation department's report, Mr. Allen has experienced a number of very significant injuries that have left him in a disabled condition, which he is unable to work in a full-time 9-to-5 sense of things, given, as I mentioned, the really significant injuries that he's maintained and really, tried to overcome over the last decade or so. But with respect to that, Your Honor, with respect to the time that he has, he certainly uses that to the most productive efforts with respect to taking care of his family. He provides a great caretaking service for his stepfather, particularly after the loss of his mother. He is a great father. He was just telling me about the overnight he got to have with his son due to a need for his son's mother couldn't care for her son last night. And we've oftentimes really spoken about the relationship that he has with his children, especially his youngest children now. And it's one of the most important things to him. And so I think he looks as a silver lining of his disabilities that gives him more time to be involved with his closest relationships. They not only provide a great productive use of his time, but they do certainly provide a great support system for him. They have been a great support system prior to this matter and certainly during the course of this, as this has been challenging for Mr. Allen. But the challenge has also been a great source of understanding. This has been a very humbling experience for Mr. Allen. He has had to confront both his understanding of law and role in society, as well as a deeper understanding of himself. We have talked repeatedly, both with respect to concepts of candor to the court, candor to court staff, and particularly after reading the PSI report. He does understand he is certainly remorseful and regretful, and certainly is taking on efforts to address that, to be a more productive, responsible citizen member of the communities.
You know what would be even more humbling? A good stint in jail.
Because that's all he does really want moving forward, Your Honor. He wants to understand that he did wrong, that he can make amends for that, and then go forward and live a productive, meaningful, and perhaps most significantly, quiet life. He wants to be able to take care of himself, his children, and his family at large. He wants to be a productive member of this community and any community that he may be in. And I do believe that with the deep understanding both of these proceedings as well as himself, he is capable moving forward in a very healthy, productive manner. I do think it is noteworthy if you do look at a prior record. His last offense of any kind was in 2013 for a driving while license suspended. He has not had any contact with the criminal justice system in the time since then for this matter. Or I'm sorry, Your Honor. He did have contact with the criminal justice system. Ultimately, that was a case that was dismissed. I should more clearly say he has not been convicted of any offense since 2013. If you further look at the record, his record does not have anything violent or assaultive. His record does not have anything substance related. His background is not one that contains history of substance abuse, substance use. And as we talked about his use of alcohol in the past, he has advised me that he does not really like to drink. When he does drink, it typically, as was in the case of this incident, occurred during a Lions game where he was watching with his son. And unfortunately, he now recognizes that there is a very necessary cutoff. People can enjoy the sporting event. Many people might like to partake with a beer or otherwise while enjoying that sporting event, but he understands even more clearly now that there are limits and we need to adhere to those limits so that we can be that productive, responsible member of the community. He's taken that lesson and every lesson gained through these proceedings, and he will channel that going forward to make sure if he ever wants to enjoy a Lions game like that again, there's absolutely no use of an automobile at any time thereafter. His history does not provide one which shows a alcohol abuse problem. And I do believe that the difficult, challenging process of resolving this matter reinforced.
It's my BS button. Here's the thing, though. It has many variations of BS, and it's really loud.
Very important lesson regarding responsible consumption. Your Honor, he is properly licensed with a medical marijuana card because that has been his primary form of treatment for the physical limitations or disabilities that he has had. He does not have a history of abusing or otherwise violating the law with respect to marijuana, and I believe has shown that he is capable of being a responsible user in that sense. But with respect to Mr. Allen moving forward, as I noted, he wants to go forward, put this behind him, not because it doesn't matter or it's insignificant, but put this behind him so that he can be that best father to his young children, that he could be the best brother to his siblings, and the best stepson to his stepfather, especially at a very difficult time, having lost his mother and his stepfather's wife. With respect to moving forward, Your Honor, the probation department is recommending a sentence, fines and costs and alcohol.
Why are you unnecessarily wasting the judicial time of this court?
I believe that is an appropriate recommendation with respect to fines and costs, particularly in light of MCL 769.5. With respect to the alcohol tether, Your Honor, I'm not sure that is necessary at this time. The reason I would say that is through the course of these proceedings, Mr. Allen has not violated the bond with respect to alcohol. Mr. Allen has not engaged in any new criminal behavior involving alcohol or otherwise for that matter. And I'm not sure that an alcohol tether will necessarily provide a rehabilitative benefit consistent with sentencing guidelines in the state, but rather it would impose an additional financial constraint that I don't believe is tailored to a productive goal of sentencing. With all due respect, Your Honor, I would ask that the court follow the recommendation with respect to fines and costs. I would ask that the court consider not ordering the alcohol tether, given that there has not been an alcohol issue since Mr. Allen was first arraigned in this matter.
All right, thank you. When did your client obtain his medical marijuana card?
Your Honor, the card was issued on May 7, 2025. However, I do know from speaking with Mr. Allen that the process was engaged in advance of the date of issuance because, as I believe we know, you have to go through doctors, submit the materials before it is issued. So I do know that he did generate those efforts prior to that issue date. And I would just further note, Your Honor, Mr. Allen did previously have a medical marijuana card. He had maintained one of the cards he had been issued previously. This was a card that was issued in 2012. This particular card expired in 2013, but Mr. Allen had advised me that he had continued to receive these cards up until the time that recreational marijuana was legalized in the state. And at that point, the cost of the medical marijuana card was outweighed by the ability to actually to obtain by way of the recreational legalization. And so when this matter arose, he did initiate those efforts to be properly licensed.
Okay, so let me ask a few questions. Did you receive that medical marijuana card as a recommendation from your treating physician?
No.
No. Do you have a treating physician?
No.
So you have continued medical problems for which you need marijuana for medication, correct?
Yes.
But you don't have a treating physician to treat you for those continuing medical problems.
No, because when you go to the doctors, all they try to do is give you pills for your pain. And I don't want to be addicted
Sir?
to pills.
Sir,
Well,
as the patient, you definitely have a right to engage in conversation with your treating physician as to the best course of medication treatment for you.
If you didn't know, y'all stink. Okay, that's just my opinion.
The concern this court has is that you have alleged that there is a number of medical conditions by which you need marijuana. But this court is very much aware that when an individual walks into a medical marijuana clinic to obtain medical marijuana card, there isn't any follow-up to confirm that that medication is in fact working as it should, such as somebody with high blood pressure has follow-up appointments with their doctor to make sure the medication is working. Somebody with high cholesterol or sugar issues.
The whole thing is hilarious. People just want to get high. Come on. She knows it. That's what she's saying. We like dance around this. Like, there are people who are legitimately using this for medical purposes, but that's like maybe 1 in 1,000. Everybody else is just trying to get high. That's why I didn't renew it when it became whatever.
So if the marijuana is for true medicinal purposes, then there should be requirements and, I'm sorry, not requirements, but follow-up appointments that are already scheduled and that you see on a regular basis to ensure the medication as prescribed is working for you. That is this court's requirement as it relates to marijuana for medical purposes, which I know I've stated to you before. And so you have this medical marijuana card that you obtained while on bond and under jurisdiction of this court without having anything from your treating physician. And further, just so you're aware, all I would need from your treating physician is some communication that that's the preferred method of medication, and you wouldn't have to even go through the steps of the medical marijuana card. And I know I've stated that to you before as well, which apparently is where things went awry with the conversation with Ms. Shaw. Council, after review of the report and recommendation, hearing from council, hearing from Mr. Allen, the court agreed that there is not reasonable grounds to depart from MCL 769.5. The court, in further review of the report regarding the report of substance abuse assessment, shows your client is a category 3 alcohol and 4 drug user. Presumably, the category 4 is based upon your client's marijuana use. Based upon that, the court does find that the recommendation is appropriate. The court's going to order 60 days on the alcohol tether. So what I'm going to do is I'm going to have you, I believe that the Wayne County Jail, I guess it depends on who answers the phone when, or responds to the email. You can go to Wayne County Jail for that. Not in custody. You just go down to the Wayne County Jail and then they can affix you with an alcohol tether. That's much more cost effective than an independent third party. The court's going to also order a $300 fine, $100 screening assessment fee, $300 cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50 for a total of $825. And sir, do you have any, I think you posted a bond. You did post a bond.
Yes, Your Honor, I was just going to ask if we could confirm with Mr. Allen, $500 bond, if that could be applied to the fines and costs in this matter.
You did.
Mr. Allen just indicated to me that he could pay the balance.
Yes.
You have $325 to pay today. Okay. Then yes, so then I will indicate that's payable today. All right, so you're going to go over to probation. And they are going to give you the information regarding going to obtain the alcohol tether.
Okay.
Okay?
Yes.
I strongly hope that you've heeded what I've stated earlier and that you've listened to your attorney with his excellent representation of you, sir, in what he stated that you've taken away from all of this. So, and I'm hoping that you are not going to verbally assault my staff as you are going back there to get information regarding your alcohol tether. Okay? Thank you. Have a good day. Good luck to you.
All right, I'm ready on Miss Maggie. How do you pronounce her name?
McGee.
Oh, that's what I kept saying wrong. That's how
all fell apart. That's how we got
That's
here.
why. Well, let's make sure. Yeah, okay. Let's make sure it don't fall apart today, because she's supposed to be in person. Miss McGee, start your camera. Okay. All right. Oh, this is case number 224518101. The people of the state of Michigan versus Adriana Ranissa McGee. Defendant is charged with 1 count of disorderly disturbance, and today is the date set, adjourned sentencing. And appearances, please, even though I said Miss McGee had to come in person. Appearances, please.
Good morning, Your Honor. Delisha Coleman on behalf of City of Detroit.
And for the record, Your Honor, Janice
I hear someone's having a birthday tomorrow.
Stevenson appearing on behalf of Ms. Adriana McGee. Ms. McGee, ma'am, will you please say your first, your middle, and your last names?
Adriana Ranissa McGee.
It was at 8:59, so I didn't do a pre-sentence investigation for Miss McGee, but we were here the other day and I mispronounced Miss McGee's name, and Miss McGee got real smart with the court and it went real left. And then I said she had to come in person that day, and then by the time she got here, I was not here anymore, and then I had her to be interviewed by the specialty court, and I understand that she was interviewed by the specialty court, and that she does qualify for the behavioral health court. So with that in mind, with respect to sentencing. Is there anything on behalf of the people?
No, thank you, Your Honor.
I was trying to request a new attorney.
Ma'am, okay.
They
And
so I came
with
down
that
to the
in
court
mind, Ms.
yesterday.
McGee, it's getting ready to go. This is why I said she had to come in person.
I did come in person. I came the day you
This
told me
is
to
why
come.
I said she had to come in person. And I wasn't
They
talking
said it
to
was a
Ms.
virtual
McGee
hearing.
because if I was talking to Ms. McGee, I wouldn't have said she. If I was speaking at that moment to Ms. McGee, then I wouldn't have said she. I would have said you. But since I wasn't speaking to Ms. McGee, that's why I said she. And then I just gave a speech and I
See, Ms. McGee, how the English language provides those hints as to who people are talking to. Oh, I love it. The rant is beautiful.
said that Ms. McGee came in person that day and spoke to specialty court. And so if I was talking about that Ms. McGee had to come in person that day, I would have said that she came in person and therefore she fulfilled my requirement for coming in person. But since I wasn't speaking to Ms. McGee and I wasn't speaking about the requirement to come in person the other day, but my requirement that she come in person also today, that's why I said what I said. And since I said what I said, and I said it the other day, and I see that this is getting ready to go south again, I'm gonna again
I'm
require
listening
that
to
Ms.
what you have
McGee
to say. I'm
is gonna
receiving.
come in person, and she's not gonna overtalk me because I am not going just not gonna be overtalked. I'm not. It's just not gonna happen. So let's do this. I know that specialty court gave her a day to come in person, and then I think she said she was when she just blurted out in my courtroom just now and didn't wait for me to acknowledge her to speak. She said she was going to request another lawyer. And Ms. Stevenson, are you aware of Ms. McGee's request that misdemeanor and felony defender be removed from the case? Were you aware of that before now?
Not until this very moment, Your Honor. I would say that we are at sentencing at this point. And if the court were to follow the recommendation of specialty court, that Ms. McGee would have another lawyer provided to her when she starts working with the specialty court.
Yeah, I know. You said that for her benefit, not mine.
Yes, Judge.
Oh, I know. Okay. So what I'm going to do is send Miss McGee back into the breakout room. I'm going to allow her to speak to you, Ms. Stevenson, regarding her requests.
Can I say the words that she said, or?
Sure. I need for you to tell me what went on.
That I'm not on that whole shit. I'm not with that whole shit.
For new counsel. And I'm going to allow you to explain to Ms. McGee or to allow her to ask questions about what you just said on my record that was really for her benefit. And then I'll decide if I'm going to hear the case on Zoom. Because I did, in fact, say I wasn't hearing her cases on Zoom. I wasn't going to hear her case on Zoom.
Oh, yes, sure.
For very reason. So she go back and you all can discuss her requests, and then we can move forward. So I'm going to put her in put Miss McGee in breakout room number 3. You can please accept to join that breakout room, and then we can go from there.
Okay. Thank you very much.
Who interviewed Miss McGee? Did Miss Warfield interview Miss McGee?
I don't think so.
Mr.
I don't think
Flanagan,
that's what
I
Sarah.
want Miss Warfield to come in and talk to Miss McGee, please.
Yes.
Okay. That's who I want to talk to, Miss McGee. Please find Miss Warfield. I'm actually ready on Miss McGee, and then I'm ready on Stockmo, and then I'm ready on Houchins. So I'm ready on McGee first. Miss McGee, start your camera for me. All right, I'm recalling case number 224518101, the people versus Adriana Renissa McGee. Today is the date set for sentencing. Appearances again, please.
And Alicia Coleman on behalf of the city of Detroit, Your Honor.
And again, for the record, Janice Stevenson appearing on behalf of Adriana McGee. Ms. McGee, ma'am, please say your first, your middle, and your last
Wait, isn't she supposed to appear in person? Did I miss something? That's what I thought.
names.
Initial. Adriana Renissa McGee.
Thank you.
All right, so we're back on the record with Miss McGee. And I had asked Attorney Warfield to come on and speak to Miss McGee. And then Attorney Warfield came out here and said Miss McGee insulted her intelligence. Or some told her she was about dumb. I don't know. So we're gonna go ahead and proceed. we're gonna go ahead and proceed. I let her talk to Attorney Warfield, and so I guess there's just no lawyer that's good. Today is the day for sentencing. Do the people wish to be heard?
The people do not wish to be heard. We leave it to the court's discretion, Your Honor.
Ms. Stevenson, do you wish to be heard?
Well, I do, Your Honor, on behalf
Yeah, she's got the same shirt on.
of Ms. McGee. Your Honor, Ms. McGee did make some representations to the court through counsel, I believe through Attorney Hall, when she was here earlier this week or whenever that was. But and I believe that Ms. McGee is in need of the support that she's seeking at this time.
And who's seeking? Because Miss Warfield said that she don't want the service.
Well, the services through DWIM that she was, I think, trying to call this a couple of days.
Yes.
Already have those
Because
services.
You're not gonna, now let me tell you what we're not gonna do is interrupt. We're not gonna be rude. That's so rude to interrupt Miss Stevenson. Because you will get a chance to speak. And then when you get a chance to speak, hopefully we won't have to interrupt you. Miss Stevenson.
Thank you, Your Honor. And I believe that that Ms. McGee is very wise in seeking the support that she has sought through DWIM, because until her appearance earlier this week, Your Honor, Ms. McGee and I have had a very productive working relationship. She has been extremely attentive to these proceedings. She did express to me remorse for the actions that she took on the date of the incident that brings her to court. She expressed the desire to fully put this matter behind her. I believe I had some notes that indicated that I had to talk Ms. McGee out of—
Yeah, Janice, we all love you, and you're doing a great job. Problem is, she's been an unmitigated B during these proceedings, and we've all seen it.
Throwing up her hands and pleading guilty at her first court appearance. I think I talked to her about the people having a burden of proof. And it's not her responsibility to prove that she's guilty. The people have to prove that. And so we have to wait at least until I can look at the case and make some thorough assessments before she pleads guilty. She was totally on board.
Oh, she's guilty. She's guilty. I don't know what she's charged with, but I'm confident she's guilty.
With that. So, I think that Ms. McGee does need the support that she is seeking of her own volition. I believe that the specialty court would be able to be of great assistance to Ms. McGee. I think once she gets things stabilized, she's going to respond favorably to the guidance provided by the specialty court through Judge Holmes and the rest of the specialty court staff. So I think that, you know, we do have a little bit of aberrant behavior in place right now. Ms. McGee, it is a little bit different than she was when she and I first started working together. And I think she's going to be okay. And so I am asking for the referral to specialty court, Your Honor.
I went mute and y'all didn't even tell me. Y'all didn't see my lips moving and y'all couldn't hear me? Okay, so what was the last thing? Did y'all hear me give the sentence at all?
No.
Oh, bless y'all entire heart. Okay, so the court is going to sentence Miss McGee. So did y'all hear me ask Miss McGee, did she want to give a statement?
No.
Oh, Lord. Y'all didn't see my lips moving and y'all couldn't hear me?
I didn't. I can't see
Hey,
it.
look up at the camera. I need y'all to look up and be in court. Let's be
You're,
present
you're
in
this
court.
big on my screen, Judge. You're,
Make me bigger. Make me bigger.
okay, I'll do that.
Like the speaker. Make me bigger. I
Okay.
need you all to pay attention in court. I'm sitting here saying a whole bunch and nobody said nothing. All right. Does Ms. McGee wish to make a statement on her own behalf? Ms. McGee, do you want to say anything to the court?
Give me 1 second. Give me 1 second.
Yeah, we're gonna wait for you. Sure. Sure. You saw her leave the room. Okay. All right, Ms. McGee, do you want to make a statement to the court on your own behalf?
I agree to the probation, reporting probation. I agree to that. That's all I'm gonna say.
All right. Then the court is going to impose the following sentence. I will sentence Ms.
Not specialty court.
I will sentence Miss McGee to a term of probation for 14 months. And I'm going to transfer the case to Judge Shannon Holmes. In the behavioral health court, I would allow Judge Holmes to set all the terms and conditions of the probation. The return to court date is October the 6th at 9:30 a.m. Failure to appear for the next court appearance, and that is in person, and the failure to appear will result in a warrant being issued and the bond being set at 5,000 cash surety plus a GPS tether with house arrest. Anything further on behalf of the defense? I mean, on behalf of the people? I'm sorry, Miss Kayla Coleman.
So I'm on probation for 14 months.
Anything further on behalf of the people?
Nothing further on behalf of the people. Thank you, Your Honor.
And anything further on behalf of the defense?
To the court, I would have nothing more for the record, Your Honor.
Okay, so what do
talk to my attorney, Mr. Stevenson? Can I talk to my attorney?
I'm happy to do that, Your Honor.
Well, y'all got telephones.
That's true, Your Honor.
Okay,
The court,
let me tell you what's not gonna happen. I could care less. Miss McGee is on here with an attitude with me like she directing me to do something. Now I gave you an opportunity to speak. I gave you an opportunity to ask me for something, anything you wanted to ask me for. You could have asked it of me, but you
said
didn't.
14 months. That's a long
time. You didn't. So let's do this. Miss Stevenson, do you have Miss McGee's phone number?
I do, Your Honor.
Then call her. That's how she can talk to her lawyer. My order is complete and court is complete. With respect to Miss McGee, have a great day and stay safe.
Thank you, Your Honor.
Oh, you're welcome.
Thank you. Thank you.
I'm ready on.
Oh, that was fun. I haven't seen this, so that was fun. But I was really pulling for Judge Bryant to throw her in jail for a couple of days for that nasty attitude. She certainly deserved it. She certainly deserved it.
Houchins. This is case number. What time did Shabazz get here?
He's been here for a while, Your Honor. I just forgot to put it in the chat.
Oh, I'm so thankful that you told me. All right, this is case number. Where did Mr. Pope go?
Right here, Judge.
Oh, I just couldn't see you. Okay, this is case number. These are case numbers. SP 1732931. The defendant is charged with lewd and lascivious conduct, and then case number 254513801. Defendant is charged with assault or some battery, and the court set this matter for bond modification hearing. Appearances, please.
Good morning, Your Honor. Delisha Coleman on behalf of the City of Detroit.
Your witness, Ms. Coleman.
I apologize, Ms. Carter, if you could state your name for the record. Unmute and state.
Good morning. My name is Theowana Carter.
Mr. Hill, I see you standing up. Are you putting your appearance on for this case too?
Yes, please, Your Honor. Alex Hill on behalf of the people, P76961.
All right.
Please, this honorable court, Larry Polk on behalf of Cynthia Hutchins, who is present by way of Zoom. My P number is 48164. Ms. Cynthia Hutchins, would you state your full name for the record, please?
Unmute your device, Ms. Hutchins. Okay, we still can't hear you, ma'am.
Cynthia Annette Houchins.
Okay, and can the person who's assisting you please move outside of the camera view?
Thank you.
All right, Mr. Polk, you indicated to the court off the record that you all, not off, we were recording, but not on the record, that you all had reached an agreement or resolved the matter.
There is an offer that has been made in reference to resolution, and ask the prosecutor to put it on, place it on the record.
Okay, so, okay. Mr. Hill, I suppose is going to do that.
Thank you, Your Honor. As to the lewd conduct charge, my understanding is there would be a guilty plea with an understanding that the parties would stipulate to behavioral mental health.
Let me ask you all this before we proceed. So, in other words, whoever asked me for this bond modification is withdrawing their motion for me to hear on bond modification?
Your Honor, my understanding is the defense is willing to accept responsibility. In light of that acceptance, we are comfortable moving this matter forward towards sentencing date without hearing the alleged violation.
All right. And so is this on my docket for?
I want to hear the violations. I heard lewd and lascivious. I want the deets. Give it to me.
Some for trial or anything?
No, ma'am.
All right. So go ahead, Mr. Hill. So it's your understanding that Ms. Houchins is going to plead guilty to lewd and lascivious conduct, and what's going to happen to the assault or assault and battery?
That matter would be dismissed, but there is a sentencing agreement, whereas Ms. Houchins would interview and attend specialty court.
Mr. Polk?
Yes, ma'am.
Is that your understanding?
It is my understanding, and I've explained it to my client.
All right. And Ms. Houchins, you've had an opportunity to consult with your lawyer and you wish to enter into this plea agreement today?
Yes, Your Honor.
Ms. Houchins, I'm going to share my screen, and on the screen will be a constitutional rights form. Have you had an opportunity, ma'am, to review for yourself or to discuss with your lawyer your constitutional rights? It's okay if the answer is no. Did you discuss your constitutional rights with your lawyer? Did he tell you about your right to a trial and you could plead guilty? Did you go over that with your lawyer?
No, Your Honor.
All right, then we're going to go over it right now.
Yeah, that is weird.
I'm going to skip number 1 and go down to number 2. Number 1 just talks about special accommodations for a handicap.
That'd be me.
You said what?
I am handicapped.
So what accommodation did you need to attend this hearing today, ma'am?
I'm not understanding what you're asking, Your Honor.
Okay, well, maybe perhaps if you just listen to me, you could hear the questions, okay?
Yes, Your Honor.
Okay, thank you so much.
You're welcome.
All right. All right, ma'am. With the understanding of your constitutional rights, do you still want to give up your right to a trial and enter into this voluntary plea?
Yes.
Raise your right hand for me, please. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right. Who's going to voir dire Ms. Houchins with respect to the factual basis? You can put your hand down.
Judge, I do apologize. I'm asking the court if you would consider a no contest plea based upon mental infirmity.
No, I need my factual basis. I need it now.
Mr. Hill, do the people have a position?
We do not object. I can put a factual basis on.
I will allow.
Thank you, Judge.
Mr. Hill.
Your Honor, this matter was ticketed, and so according to that ticket, on or about May 26th of 2025, Ms. Cynthia Houchins was present in the area of City of Detroit, County of Wayne. She was in public at the time, and she, in contrary to MCL 750335, did make open and or gross lewdness or lascivious behavior by exposing her genitals. With that, the people are satisfied.
Satisfied, Judge.
All right. The court
I might have to clip exposing her genitals.
is satisfied. Will accept that as the factual basis for the plea. Mr. Pope, I know you are a very busy man, so my question is this: I'll give you a choice, and I guess as well as I'll give Ms. Carter as well.
Ma'am, are you a whore?
But I can call specialty court now, and Miss Warfield was on earlier. I could call her now, see if she can come back and speak to your client. If not, if you or Miss Carter don't want to wait for that, then I can give you a date to come back for sentencing. I won't order a pre-sentence investigation since the agreement is specialty court. So do you have time for me to see if Ms. Warfield could come back, or do you want a new date? That's to Mr. Polk first.
I absolutely have time.
All right, Ms. Carter, you have a right to make a victim impact statement for sentencing. So do you have time to wait? I want to call in the specialty court coordinator and let them interview Ms. Houchins, and then I can do the sentencing today. Do you want to wait for me to do that?
Yes, ma'am.
Okay, so Ms. Carter, I'm going to put you back in the waiting room. Mr. Flanagan, call and see if Ms. Warfield or someone else can come on now to interview Ms. Houchins, and then I will do immediate sentencing.
Thank you very much, Your Honor.
All right, you're welcome. Ms. Carter, I'll put you back in the waiting room.
Coochie. Gotcha.
And you're going to wait for the specialty court coordinator to come in and talk to you, okay?
Okay.
All right, so give me one. Uh-oh. Okay, Zoom is doing its own thing to me. Mr. Flanagan. Oh, there it is. Okay, never mind. I got it.
I mean, seriously, you don't have to say much. I just, she exposed that to me. Okay, we all understand that. It's not something you want to see.
It let me do it now. All right, I'm going to put you, Ms. Houchins. I believe someone was assisting you. It's going to be a prompt to pop up on the screen that says join the breakout room. Can you all join the breakout room? Hi, Ms. Warfield.
Hey, Judge Bryant. Hi. Sorry, they got me in another courtroom too.
I know. I mean, you know, now if you let her, she'll have you working as hard as she is. Okay.
You know, exactly. And that's another conversation for another day, though.
Okay.
So
because there's a person in my courtroom that they want interview, but I don't know if they were going to call you.
They will. They did. I'm going to come down.
Okay. For the one I just sent you in, Miss Houchins.
Yes, for Miss Houchins, Your Honor. She is eligible, due to her criminal history, lack of criminal history, for the program. However, there is a concern because she's currently taking opiates.
Hold on.
Oh.
Mr. Polk, is he in the courtroom?
I'm here.
Okay. I just wanted to make sure he could hear what you're saying.
I can.
Go ahead.
So there is a concern because of the medication she's been prescribed due to a recent surgery that she's taking that would not make her eligible for our program, Your Honor. So
but if you gave her an alternative non-narcotic, it could work, right? Or no?
Correct. However, she apprised me that she's not sure when she'll be able to get back with her doctor to see if that can be prescribed.
So we can get her back there. Mr. Do you want to go in and talk to your client? Because they're saying, because that means the whole plea fall apart.
And that's the thing, Your Honor. I want to make sure that we can we're not setting her for failure because Judge Holmes will not accept opiates into the program. So we would have to get it to where her doctor will have agreed
let me ask you this.
Mm-hmm.
What if after I had made the other lady wait, what if I gave her a regular sentencing date that gives her an opportunity to go and get an alternative instead of trying to sentence her today?
That would be my recommendation, Your Honor.
All right, Mr. Polk, I'm going to do that. And then you can talk to your client because that means the whole thing falls apart.
Yeah, but I know that she recently had some back surgery.
Right.
Walking with a walker. Okay,
so then I'm going to bring her out. And then All right. And then I'll bring out the witness who has, oh no, oh yes, okay. And then I'm gonna bring in this witness. Then I'm ready on King and Williams, and then Miss Warfield said they're gonna come and talk to Mr. Shabazz too. Miss Saverson, she might be.
Yes, I'm here.
Oh, okay,
Hi.
there you go. Hi, Miss
Okay.
Saverson. They still haven't come, Miss Saverson.
Oh my goodness.
Yeah,
Okay.
Mr. Flanagan, did we check? I don't think I asked you to, so I apologize. This Miss Saverson is here for Mr. Stinson. Did we check to see if Mr. Stinson is in custody?
Not with the jail when they were on. I'm checking Sheriff Connect now.
Okay.
And Sheriff Connect does have him in the Wayne County Jail, Your Honor, so I'll call them.
Oh, so hold tight one more minute, Miss Saverson.
Okay. We'll do.
Okay. Yes. Okay.
Okay,
Hold tight one more minute. We check the jail.
Okay.
Okay. All right. All right. Back on the record and with case number SP 17329-361, the people versus Cynthia Houchins. Appearances again, please.
Good morning, Your Honor, or good afternoon, Your Honor. Alex Hill on behalf of the people. Also present is our complainant, Ms. Carter. Ms. Carter, will you unmute and restate your name for the court?
Yes, Theowana Carter.
Thank you, ma'am.
Your Honor, may it please this honorable court, Larry Pope on behalf of Cynthia Hutchins. My P number is 4164. Ms. Hutchins, would you state your name for the record again?
Cynthia Houchins.
All right. So I was attempting to make immediate sentencing possible. However, specialty court did interview Ms. Houchins. They did confirm that she's eligible to a degree. However, there is an issue with medication that we need to resolve in order for her to be fully eligible for the program and to see if we can in fact honor the plea agreement as opposed to setting it for trial. So, or the parties reaching a different agreement. So what I'm going to do is set the matter for sentencing to give two things the ability to take place. I suppose we're going to, I don't know if specialty court will give the recommendation for the medicine alternative, but for Ms. Houchins to make an appointment urgently with her lawyer, with her doctor, who her lawyer will, I guess, talk to her about facilitating, so you can get an alternative prescription. Otherwise, the plea agreement doesn't work. And otherwise, we're going to have to do something else, which, yeah, okay. So, we know that there are alternatives because she's not the first person nor the last to have this surgery. That is many of people in specialty court that had to get an alternative prescription, and they do work. So, Mr. Polk, are you available on November 3rd or 4th for the sentencing?
November 4th, I am.
All right, let's set the sentencing for November 4th. Ms. Carter, again, you have a right to be present to make a victim impact statement, or you can give probation your victim impact statement, or you can, be present and not make a statement. You just have a right to be present, okay?
Thank you.
All right. So November the 4th at 9:00. And that can be, the parties can appear on Zoom or in person, whichever you decide to do, okay?
Very much, Your Honor.
All right, then we're all set. Have a great day. Stay safe.
You as well. It's always a pleasure.
Always a pleasure.
Oh man, I want to hear the victim impact. I want to hear the story. But they're coming back. But you don't know in that room. You don't know in that room if they're going to stream it. Oh well. Oh well. There you have it. Lots of good stuff. Lots of fun stuff. It was nice to see Judge Bryant. I still get her cases now and again, but she doesn't stream consistently. So it's just every once in a while she's on, and then usually something good happens. This is cute. Jim, come on. Better research. I like that. The implication being I did some research in the first place. You're just playing. I know it. I know it. All right. Yeah, it's my understanding it's Andrew's birthday tomorrow. I was told this information. I was afraid I'd forget. But, if he's around tomorrow, you can you can do what you will with that information. All right, everybody. Thanks for coming out. I appreciate it. I'll see you soon.